I'm a bad mood, gotta keep it tight. Hold my baby squid, keep him out of sight. Talking about my life, government, stay away. 55, I'ma do it my own way. Squid in the ocean, swimming all alone. Ain't nobody telling me where to go. Living free, gotta stay true to myself. No need for interference from anyone else. Squid pro quo, that's the way to be. Living on my terms, setting myself free. I'ma to my baby, protecting with my no government intrusion. I control my life.
Hey y'all, welcome back to the non-drama channel. I pinned a comment that says, if you troll, you will be auto-banned. All my mods, at least I think all my mods, have the list of auto-banned people. You decide to type anything in my chat, whether it is anything to do with drama or not, because this is not a drama channel. You will be auto-banned. So have fun. Hey everybody. Sorry I'm a little bit later than I would be. I had to run to town. 40-minute drive, you know. Got some stuff done at AT&T for internet wise. Because I got a new phone yesterday. When I told my dad I got a new phone, his first thing was, you threw your phone at the wall, didn't you, and broke that shit. Pretty much. No, I didn't. Baby Squid had dropped my phone like a month ago, 2 months ago, and the back of it was cracked. And I decided to get an iPhone 16 because my phone was done being paid for. So I was like, screw it, let me get a new phone. Hey, Unhung Hero, suck it trolls, pretty much. Flash fan is always good to see you. Uncle Buck, hey. Cindy, I don't make empty threats. And I don't do drama. I will cut your drama off at the pass. And the funny thing, okay, I'm gonna take 2 seconds to talk about this. The funny thing is Bruce is like, she filed a complaint with the police because of a troll. No, I filed it because of the threat for CPS, and I ain't taking your fucking shit. And the only way to stop you guys from being complete and total fucktards is to file a complete police report because y'all broke the law. Stop breaking the law, and there will be no police reports filed. And Bruce, as soon as I figure out that a certain troll is you, I'm filing a police department with your, not with Massachusetts State, but your specific district, because I know where you live. So just you know, FYI. Hey, Rosalind, get back to work. You kill it at work every day. Good. Get back to work. Hey, Jen and Roy. Automan rollout. I don't even give a shit if they're trying to cause drama or not. My mods will either time them out for 24 hours or point them out to me so I can block them from the channel completely, because I don't do your crap. Like, thanks, Unhungry, over the $5 super chat. Megan giving me tech support PTSD with her Thrustmaster. So you started at just the right time. Yeah, I was in my car listening to that on the way home. And I mean, of all the things to call something, and I know why they called it that, because it's a wheel. They did things with cars and flight simulators, thrust. But, like, did they not see the innuendo that was going to come from that and all the jokes? And it's only right that Megan ordered that one, you know. I don't play. So I changed the time from 3 to 3:10 because I was running late. I needed to get home, do some stuff for myself, you know, take care of baby Squid's diaper, get her some lunch. And this is my lunch, by the way. So I'm sorry if you don't like me eating on camera. It kind of happens from time to time, considering like I'm trying to do 80 things at once, and I worry about feeding her before myself, because, you know, that's what a That's what an attentive mother does. Since I'm home with her 24/7 and, you know, the hour and a half I spend on YouTube every other day is like me ignoring her. And oh yeah, she's getting the iPad with the dreaded Apple Pencil after she gets done eating, because she's not allowed to eat and play on my iPad at the same time, because that's just a mess waiting to happen. Bullying is bad, but I will not be bullied. I don't take kindly to threats, and I do not make empty threats. That is the reason I went to the police, because I said that I was going to, and you kept pushing. And when you kept pushing, I don't make empty threats. So anyway, getting to why we're all here. Sarah Boone had yet another motions hearing today. And you know, I forgot the Pop-Tarts in the car. Heroes and villains. Deep fried tarantula. I know who you are too, buddy. Nice try. Unhinged. I call him Unhinged Hero all the time, but that's because he's my friend. So, you know. So we are going to get through this. They didn't start. This Law and Crime video is 3 hours long. Well, 2:58. They did not actually start until 43 minutes in. So, like, we're going to see, and we're going to play this back at 1.25 because we all know how James Owen speaks, and the less time we actually have to listen to it, the better off we are. So, she is being brought in her shackles. Uh-oh. My mom texts me. Oh, yay. My mom went with me to run an errand because we both decided to get something. And the pink handcuffs are a nice touch, though. And an hour and a half later, she finally got it. So maybe she can find Baby Squid's shoe at Walmart. Because in my Mom of the Year award, we get out to the cart when we went to Walmart. I'm carrying her and the bags. No cart required. But the reason I work out is so that I can hold her and the groceries in one trip. And we get to the car and she only has one shoe. And I'm like, when did that happen? We were checking out and she had two. So we, you know, hopefully. And let me put my, my overlay over the Cook and Crime logo. Gotta fix the hair. Well, I don't think she did it on purpose. I think when I pulled her out of the cart and I lifted her up, we caught the shoe. That's my guess because when we were checking out, she still had it. So no, but good thing is my mom is headed there now to do her own shopping, and she might look for it. And the door greeters, we go to Walmart enough for the door greeters know me and Baby Squid. So if she asks, you know, if they found a shoe. Plus, she was growing out of them anyway. In like another week, she wouldn't fit into them, and she has more than one pair of shoes. So it's not the biggest deal, but like, you know. Yeah, Mom, Nana Squid to the rescue. And yes, I did get it. I watched part of it. I just didn't want to stream it because I've got so much other stuff to stream. We still have to do Carly Gregg updates and updates to Hot Car Case and just we did the
William Shea for the state.
Is his head shinier than yesterday? Or is he just sweating?
Ma'am, good morning. Can you state your full name and date of birth for the record for me?
10-10-77.
Ms. Boone is seated at council table wearing a dark gray suit and a yellow blouse. She is in custody. However, she is not being shackled for the purposes of the trial based on the court's prior findings. We're here to conclude the objections as identified in the state's response to defendant's fifth amended reciprocal discovery exhibit list. The court has reviewed the objections and the defendant's fifth amended reciprocal discovery exhibit list. Anything else we need to address, state, before we begin addressing those objections?
Judge, I do not see a written order from yesterday's rulings on the court's website. I want to make sure I am crystal clear as to what the court has said is going to occur during the trial regarding opening statements by either party and so on and so forth, so that I am not in violation of any motions in limine or any case law that presides over what I can say or not say.
Okay. Madam Clerk. Were you anticipating a written order on the motions in limine?
I felt like I heard you say everything that I anticipated was going to be put at least on court minutes by the clerk's office. I wasn't anticipating any type of written.
Okay, that's what I want clarification on. Thank you.
But I just do want crystal clear clarification as to what we are both doing. Based on that, I have some things that I would like to get on the record for post-conviction matters.
Sure. All right. Madam Clerk is pulling up the file now, sir. Give us a moment. You did not. Okay.
Are you feeling any better?
Madam Clerk is advised that court minutes were not prepared for the ruling from yesterday due to it taking place during the trial and jury selection. So digital was not providing recording services yesterday. So it would have been Madam Court Reporter. So I would have to beg and plead if she's able to get me a copy of what it was so that it can be re-reviewed so that we're all on the same page for that. Madam Court Reporter, how long do you think that would take you?
Yeah, Ong Hero, but it's cold
Is that
today.
acceptable?
It is.
Can we address it at
cold. It was
1:30 before we
35 degrees when I woke up this morning.
It makes it very difficult to prepare for opening statements.
Hey, Dad.
What I can say.
No, I agree with you, and I'm not trying to, submarine anybody or put anybody in an inappropriate box,
I
but
understand, but I need to know what I'm going to be allowed to say.
I don't disagree. But is 1:30 acceptable? Okay, well then, short of taking a break right now and having her create it, I don't know what else to tell you. State?
We have an out-of-state witness and people that are scheduled to come in, so we do see problems with that.
Okay. I don't know how long jury selection is going to take this morning. I can't recall off the top of my head how much time the state said, or the defense said they were going to need for the purposes of their questioning. So, Mr. Henderson, how much time do you think you're going to need, sir? Okay.
And if they do start today,
Correct.
I will be doing it tonight instead
Correct.
of the Thursday night politics stream. We will just cover Sarah Boone.
Mr. J?
I just need that ruling so that with enough time to prepare.
I understand. So the way I see it is we've got a couple of options. We can, and there's no good way to cut this up. One, we can wait on the objections, which I know you do not want to do. Or we can stop now. Madam Court Reporter can provide a rough draft of what was ordered yesterday. We could go over it and review it, make sure that we're all on the same page as to what the court's ruling orally was yesterday as to the various motions in limine. Then we can continue with jury selection, or then we can pick up with the objections. I'm amenable to however it is you want to proceed. I understand your concerns of running afoul with a motion in limine. I totally understand that, but it will take her some time to prepare this.
I'm fine with either letting her do that now or letting her do that after we argue this hopefully last pending motion in limine, but prior to getting into jury selection so that I have time to rework what my opening statement will be based on the ruling during Mr. Henderson's voir dire.
Let me then ask this question. Assuming we get a jury this afternoon, what are the concerns with starting tomorrow morning with openings? Is it due to out-of-state witnesses that may be unavailable or because of their schedules?
I feel like if we have time, we should at least get into preliminary instructions and opening statements and use every waking moment we have to not waste these jurors' time until 5 o'clock today.
Okay. All right. Madam Court Reporter, how long do you think it would take you? Is that acceptable as opposed to in print? She could go back and pull back the audio from and re-review it and just provide it to us now? Okay. All right. Then we'll take a short recess. Just let us know when you're prepared to give us that ruling, and then we'll go from there. Anything else we need to discuss before we take this brief recess?
No, Your Honor, thank you.
State or Ms. Rowans?
Yeah, it sounded from the.
How long do you think? 10, 15, 20? Okay, great. All right. We'll be in recess till 9:45. Thank you. Yes, sir. Yes, sir. Yes. You're talking about the motion limine regarding anticipation of affirmatively pled intent to use battered spouse syndrome evidence? Fine. Okay, well, that saves me some time then, so I appreciate that. All right, so do you have any objection then, Mr. Henderson, to the granting of the state's motion in limine, which would allow the state to be able to outline in opening statements and present evidence in the state's case in chief in anticipation of the use of the battered spouse syndrome defense at trial? All right, motion's granted. All right, we'll be in a brief recess till 9:45. Off the record, thank you.
So Jen, that's what it sounded like. It sounded like if they actually get a jury, they will be starting opening statements. But since it's probably already about that time, and they'll go till 5 o'clock. But if that happens, we will just cover it tonight at about 8:30. It's Flash Fan is looking at the jury selection stream now. Henderson is still questioning jurors. So if they pick a jury, and if they actually get done and they do opening statements, which I'm not thinking that they're going to, but if they do, I'll cover it tonight. If not, we'll go over the Carly Gregg stuff tonight at about 8:30. Mr. Squid isn't working tomorrow. So tomorrow we are doing family day at the fair. We are watching one of the pretrial motions for Sarah Boone. She, long story short, in February of 2020, right before the pandemic, she decided to play a game of hide and seek with her boyfriend, who they both have a history of mutual destruction. DV. He was 5'0", 105 pounds. And he got into a suitcase. She zipped it up, and the next morning he was still in there, and he was not with us. She recorded it. She recorded a video. At least the video that we've seen, is quite disturbing to watch. It is out on the internet, but basically she records it, and he is begging, saying, "Sarah, I can't breathe. I can't breathe." And she said, "This is what it feels like when you choke me." And she laughed and went, "Shh." It was disturbing, and it was creepy, and she's gone through, this is her 9th set of attorneys. Some conflicted out, but most of them did not. She is very difficult to work with. She was pro se for a while. And yeah, we call her Saint Sarah of the Samsonite. That was not a quote from me. That is a quote from one of my viewers and friends, AT1, my LPO. He said it in a comment, and I stole it. So I have the timestamp of what we are listening, or when they come back. So I will fast forward to that, because Lord knows we don't want to look at a clock. I do have a new intro that I'm trying to make. Shizzy Wiznut made me a song, and I am working on getting a video made for it. And when I get a new video for it, it will be debuted. I just have to take the time. She's been charged with second-degree murder, and please, and this is why I was at AT&T, because we're changing internet companies, because ever since the hurricane, Xfinity has been a unsung hero. The Oracle knows who I am. And apparently she knows more people in my family than most people because they aren't alive anymore. Interesting how that works. When we find a time to do a full reading, would it be okay if I streamed it? Or would you want me to do that, keep that private? Completely up to you. She has her own channel, by the way, so go subscribe to her.
Okay, Ms. Boone is seated at council's table wearing the same clothing from this morning. Ms. Boone, a third of your defense team is not present at the moment. Are you amenable to proceeding without Mr. Beck being here? Okay, thank you very much. Oh, that cures itself. Counselor? Thank you. Record reflect that Mr. Beck has just entered the courtroom. All right, folks had the opportunity to review the excerpts from the motion in limine hearing from yesterday. And my understanding is both the state and the defense were provided copies of same. Mr. J, is that accurate?
Oh yeah, and any
Mr. Owens,
trolls
is
that want to
accurate?
come in,
Okay.
this is my dad.
The court's reviewed it.
I
Are there any
get my
questions with
attitude from
regards to the
him.
court's rulings on that motion?
Yes, Your Honor.
Yes, sir.
Saying that's your warning.
Based on,
Sure.
I'm gonna turn off my camera real quick. I have to
Court's
wipe
providing you
ketchup
a
off
printed copy, sir.
baby squid's hands and face.
Bless you. Have you had the opportunity to review that excerpt yet, Mr. Owens? All right, go ahead and take a look at it.
Hey, once we get done eating, we like to finger paint. Hold on, I gotta wipe it off. There we go. You got ketchup on your dress. Here we go. I did not. I told my mom, but I didn't tell my
All
dad.
right, Mr. J, you may proceed.
thank you, Judge. We are referring to a rough draft printout that the court reporter made. It's 4 pages of part of your rulings from several motions yesterday. But in this one, it's on page 1, lines 22 through 24. Part of court's ruling was it's indisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court prior to battered spouse syndrome evidence coming in. And perhaps the state wasn't clear in its request, and I apologize if I was not in our motion, though. But paragraph 24 of the state's motion includes a quote from the Holland case. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. Holland versus State, 916 Southern 2nd, 750, page 760 of that opinion, a Florida Supreme Court case from 2005, which was quoting Quintana, Quintana versus State, 452 Southern 2nd, 98, page 100, a Florida first DCA case from 1984, also quoting Williams versus State, 252 Southern 2nd, 243, 246 is the page, Florida fourth DCA, 1971, Reed, REID versus State, 213 Southern 3rd, 1110 at page 1111. Florida 5th DCA 2017. Rudin versus State, 182 Southern 3rd, 724 at page 726. Florida 1st DCA 2015. So what we were asking for is, in addition to the battered spouse syndrome expert testimony, to not be mentioned prior to an overt act being laid, was any evidence of the victim's character, including reputation or prior bad acts. We apologize if that was not clear, since the motion is titled the battered spouse syndrome evidence, but the backbone and basis of that battered spouse syndrome is obviously prior bad acts by the victim. So we are seeking a pretrial ruling as well on the admission of prior bad acts, specific bad acts, or reputation evidence of the decedent.
Thank you. Response.
I just have a question as to what time. Are we talking about court hour? Are we talking about opening statement? What time are we talking about?
During the testimony in the trial.
That was my takeaway.
He's absolutely correct.
Okay, the motion's granted. So the court's going to rely on that specific excerpt in Holland 916 2nd 750 at pinpoint 760 through 761. Beginning with, as a general rule, evidence of a victim's character is inadmissible to prove actions in conformity with it on a particular occasion, section 90.40414 statutes. However, when a claim of self-defense is raised, a defendant may introduce evidence of the victim's character to establish who the aggressor was, or that the defendant was apprehensive of the victim at the time of the homicide. Internal citations omitted. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an, quote, overt act by the brackets victim, end bracket, at or about the time of the bracket incident, end bracket, that reasonably indicated a need for bracket self-defense, end bracket, internal citations omitted. That's the standard. So hearing no objection from the defense, the motion will be granted. Received and understood. Any other clarifications for the purposes of opening or trial based on the court's oral rulings on the state's motions in limine yesterday?
Your Honor, and then the only other thing that beg in the court is that we can have some written rulings on all the motions that were ruled on yesterday at some point. Record for this.
Okay.
Yes, ma'am.
All right. Thank you. Anything further from the state before we proceed with the objections? Defense.
I will start out of the way just because they are married together.
That is correct. And the court ruled specifically on that yesterday. And that's in the excerpt that was provided to you and your co-counsel. Right, thank you.
I also believe part of the court's ruling was that the testimony that was proffered, the expected testimony of the defendant that was given to the experts, I believe the court's position was if that is the testimony, then that is not an overt act.
The court's statements yesterday speak for themselves. I'm not going to rehash that matter today. Anything
I
else,
like
Mr.
this
J?
judge. I really
Anything
like
else,
this judge.
defense? All right, let's proceed with these objections. The court again has had the opportunity to review that fifth amended reciprocal discovery exhibit list filed by the defense, I believe back on October 2nd or the 3rd, and the court was provided yesterday the actual exhibit list itself and the state's response and objections to same. There's no need to go over the items for which the state has no objections. So state, I would ask you just to provide as to the ones that you have objections for, and I have notes with regard to all of them. So you may proceed, sir.
Judge Cranick still on point.
I think that's the easiest way to go. I know we start with item 1 and then go 3, 4, et cetera. So we can ping pong it back and forth from there.
All right, regarding item number 1 on the fifth amended reciprocal discovery exhibit list from the defendant, I do not believe we have received those records.
Response from the defense.
Referring to 1A is all the state's evidence that you believe you can use, and I labeled that as paragraph 0 in my response. So specifically talking about your paragraph that you labeled 1, certified medical records from Advent Health Orlando, paren, not yet received by the defense, paren. It's not yet received by the state, paren.
The defense has not received those records.
Motions or the objection is sustained. Moving to 3. Are these the 550 pages that we addressed yesterday?
My belief, and again, none of the exhibits are numbered as they get disclosed to the state. They're not Bates numbered. I do that myself. But what I have and what I believe is states 2 was 81 pages of records regarding treatment by.
I'm not talking about 2. You don't object to 2. Talk about 3.
Well, I do need to talk about 2 now because
Okay.
this morning after having previously already been given 81 pages of records that purport to be from Winter Park Advent Health regarding the treatment of Sarah Boone over a variety of different dates spanning 2018 to 2020. After having received those, reviewed those, and made my decision on not objecting, this morning I was given a thumb drive from the defense, which contained 119 JPEGs rather than a single PDF with 119 pages. A JPEG, for the record, is a digital picture. They were upside down, they were sideways. I got them all formatted. I was able to read them while we were waiting for Madam Court Reporter. They do not appear to be completely the same as what has been previously provided by the defendant in regards to Winter Park's Advent Health treatment of Ms. Boone. So I just want to be clear that now, since the state's response, there has been some sort of change in what those records purport to be. And we are objecting. We are requesting a Richardson hearing regarding the 119 JPEGs that we were provided this morning in regards to defendant's exhibit number 2.
At this point in time, the court is going to proceed with a Richardson hearing. Defense? Correct. My understanding, based on what Mr. J just provided, and based on his response, is that there were 81 pages provided to the state on or about September 27th, 2024. State had no objection to those. State further identified that this morning a thumb drive of 119 JPEGs evidencing something else was provided. And under the mandates of the 6th District Court of Appeal, based on Young v. State 369 Southern 3rd 1243, I am required to conduct a Richardson hearing. The court is conducting a Richardson hearing at this time. The 81 pages are not at issue. And what do the 119 pages evidence?
Hey, Spawn Trooper.
I need more specifics than that. I don't have a time frame. I don't have when. I don't have what.
Well, it's gonna have to be matched up with the dates that she was injured, which would coincide with the
But that all goes to the irrelevancy issue. We're conducting a Richardson hearing at this time. So I need to address the inadvertence or willfulness of the discovery. I need to address whether it was trivial or substantial. And if I don't know what's in these 119 pages, it's difficult for the court to determine whether or not this is a trivial or substantial matter. Are these items that were previously produced in the 81 pages? Are they different? Are they different events? Are they different injuries? Are they different things? Moreover, I need to make a determination as to whether this violation had an impact on the ability for the state to properly prepare for trial. Those are the 3 prongs that I need to address.
And a Richardson hearing came from the Supreme Court case, State of Florida v. Richardson, I think. That has to do with the discovery and timing of discovery. I'm not a lawyer, so take this with a grain of salt, but this is just what I know from.
medical records of Sarah Boone that we got from one of the previous lawyers that we had sent to the state. The other medical records were those that we had requested directly from the hospital that we got last week or late last week. We just failed to immediately provide those.
When did you receive them last week?
I'm not sure, Judge. I have to get my secretary. I have to break.
Okay, I'm going to continue with the balance of the objections, and we'll circle back on the issue with regard to this objection so that you can provide when, where, how, what. Understood. All right. I'll make a note to circle back to this issue. Moving to number 3. Is this the Advent Health Winter Park Jorge, not yet received by the defense. State's response reveals a motion in limine was filed regarding this motion. Is that the 550 pages that we addressed yesterday?
Yes, Your Honor, the state still has not received a whittled down exhibit that they plan to introduce at trial.
Busy
The
but
court
surviving.
ruled on that yesterday regarding the blood alcohol content records, and the narrative would be admissible.
I'm still waiting for those particular pages to be disclosed.
Okay.
You want the exact pages for those-
Yes,
the DAC and the narrative?
that's what's going to be offered into evidence at this point in time. Appreciate it.
I got staff.
So as with regard to the state's objection to item 3 that was previously ruled upon yesterday, is that the same with regard to the state's objection as to item number 5, certified medical records, Advent Health, Ultimate Springs, George?
I believe so, without being able to tell. Advent Health, it just seems to all come from Altamont Springs, the records. So I believe that is all encompassing, but we don't have an objection other than the ones previously noted for 3 and 5.
Okay, thank you. Moving now to item number 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they also have not yet been received by the state.
I think, did we address number 4? We went from 3 to 5.
Oh, I apologize. You're correct. 4, certified medical records, Advent Health, Altamont Springs, Sarah, not yet received by the defense. I'm assuming also then state you have not received them.
I believe the only records until this morning that I had was the 81 pages from Winter Park disclosed on September 27th, 2024. If there is something that they have from Advent Health, Altamont Springs, I don't believe I have that.
Defense.
Judge, we have not yet received those records. We had Sarah put in a final medical release. And we have sent requests to various medical facilities asking for records. We're just waiting on response.
And damn, I forgot the Pop-Tarts in the
The
car.
objection sustained. Moving to 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they have not yet been received by the state either.
Last night, after business hours, I received 382 pages of jail records regarding the Boone. Once again, I had to spend my personal time reviewing these records.
You're a lawyer. You don't have personal time.
Of the 382 pages, probably fewer than 5% refer to her mental health and the psychiatric treatment that gets provided to inmates at the Orange County Jail. The other 95+% of these records is all about physical treatment, COVID tests, things I won't outline here unnecessarily, since I do not believe these records will come in, but all of the things that you would expect a middle-aged inmate to have to go through for the course of 4 years. The state just is having great difficulty understanding what, if any, pages of these records are relevant. On page 135, there's records from part of her intake procedure on February 26th, 2020. On page 137, that's the initial screening when she came into the jail on February 25th, 2020. Page 137 and 138 include this initial intake screening. But from there, we get pretty far removed in time, pretty far removed in relevance. So the state is objecting to the introduction of these records. Even her intake screening on pages 135 through 138, I don't understand the relevancy of it. She indicates panic symptoms. She's semi-cooperative, has poor insight, unrealistic expectations, wants holistic treatment, doesn't like being housed alone. The screening on 225 goes through alcohol abuse, yes, type, spirits, not wine. Last used 2/23/20, several times a week. The intake screening also includes a history of violence towards others, yes. So there's no psychiatric treatment records for treatment for trauma. Any of the recognized trauma diagnoses in the DSM-5, PTSD, or any of the other trauma symptoms that can be diagnosed. There's no records of any treatment of that. It's just the anxiety, which, having read the expert depositions, I'm sure you understand that was pre-existing before the jail. So our objection is we don't understand the relevance of these records. They do not go to her subjective state of mind on February 23rd, 2020. They do not go to help us understand whether somebody in her position was objectively reasonable on February 23rd, 2020. And quite frankly, most of it's just embarrassing and irrelevant. And it would bog the jury down, much like 487 pages of Jorge Torres's records. There's just a lot of COVID screenings and blood test results, and we struggle to see the relevance, Judge.
Thank you. Response?
Judge, it's similar to the state about 10 days ago, sending me over 500 pages.
We addressed that yesterday. That's not germane to the issue.
As soon as I got the medical records, you mentioned anxiety was pre-existing. No, that's not what their expert, Dr. Warren, opined in her deposition. The anxiety she may be suffering from at the jail was unmitigated. So there are questions about that. But generally, you get these records, as you know, you have a forensic psychologist evaluate patients.
What is the relevance of these records? What do COVID tests have to do with anything in this case? What do blood tests have to do with anything in this case? If they don't, then what of these 382 records, 382 pages of records are relevant? What specifically is relevant? What page? What date? What document? You're not answering my question, counselor.
Get him, Judge.
They are listed on your exhibit list. The state is taking the position that these may be sought to be entered into evidence.
Then why did you give them to the state? Oh, to waste their time.
The depositions of all three doctors predate their request for these records. So it's pretty unclear whether any of these experts have already reviewed these records. Now we're going to have to address, when do I get to depose their doctor, Dr. Harper? If she has not reviewed these records yet, when do I get to depose her? Who's going to pay for the expedited cost for the transcripts? What relevance is it to her if she hasn't reviewed these records? They got these records post-deposition, post-evaluation. The last date that I believe she saw Ms. Boone was September 30th or October 1st. And then we took her deposition either the 1st or the 2nd. This is also a problem, even if it's just going to be relied upon, not introduced. And I appreciate them letting us know that they don't seek to introduce these records as evidence, because of course, experts can rely on inadmissible evidence if within the course of that area of expertise, it's the type of evidence that's being relied upon. But how are these records relied upon if they acquired them after we've done all the depositions? Now, Dr. Harper did say that she relied upon some jail records during her deposition. State didn't have those at the time. I don't know what the date span is of the records that she did review at the time of her deposition. So now we have new issues to confront. We would like to know whether or not their experts have been provided these new records so that we can address that.
Mr. Owens? So she has not yet reviewed these yet, correct? Okay. Okay. State with. Okay. So state, understanding that tactical decision and that Dr. Harper is not reviewed and seemingly will not be relying upon these experts, does that cure any concerns that you have?
Yes.
All right. Then based on counsel's representation, the court's not going to sustain or overrule the objection, as the defense has identified they are not going to be seeking any of these 382 pages into evidence. Moving now to 8, 9, 10, and 11. There's no issue with regard to the body cam footage, but there is to the police report itself. What is your response to that, Mr. Owens?
Let's just go back and
Okay. Does that cure that understanding? Okay. All right. So based on Mr. Owens's representation, as those items will not be sought to be moved into evidence or received into evidence, but only for the purposes of refreshing a recollection, the objection is not sustained nor overruled, as they're not going to be sought to be entered into evidence. Moving to Exhibit 17. No, I'm sorry. 16. 16 is a repeat of 11, so the court's going to adopt its, or similarly with regard to that exhibit. Mr. Owens, are you only going to be seeking the arrest report for the purposes of refreshing? Okay, so court same ruling with regard to Exhibit 16 as with 9, 10, and 11. Moving to 17, the jail calls involving defendant and third parties. State, anything else to add other than your written objection? Response.
The defendant is not intending to introduce.
Okay, the objection is sustained. 18, prior criminal history of George Torres not yet received by the defense. Has the state received that?
Other than the arrest history that has resulted in interaction with the state attorney's office, we have not. He's not a testifying witness. So obviously, provide, if they can't get it through intelligence rap sheets of witnesses, but he's not a witness. So we have not done anything other than had discussions about prior interactions with the state attorney's office.
Sorry,
Response.
guys.
Mr.
I know
Owens.
the audio sucks.
Okay.
I know we had some priors in Pennsylvania,
I'm just trying to understand, are they seeking to introduce some sort of paper, or is this just the broad notification that Ms. Boone, when she testifies, will be testifying about any prior incident of violence that she wants to regarding the decedent? Can't rebut it.
What is it? Is this oral testimony? Because this is an exhibit list, so that's my confusion. If it's oral testimony, that may be a different critter once the overt act is established under Holland.
she's going to testify to it, and then sometimes in that evidence may be used to refresh the officer's testimony. The officer's testimony is to cooperate, serve as testimony about arrangements, photographs, officer physically observing things or that's the nature of this. I don't think there is going to be anything about prior criminal history other than what she's testifying.
Okay, so there's not going to be any documentary or physical evidence that's provided, informations, charging affidavits, a criminal history report, anything tangible that's going to be offered to establish that criminal history other than Ms. Boone's testimony? Is that your position?
Yes, unless there's some dispute about that, that we have to cooperate and ask the court to take some judicial notice that there was a case file that was set up to handle that criminal prosecution.
Okay. Mr. J?
I don't know that papers generated by a government agency is relevant. The disposition of the papers that were generated by some government agency is relevant. What's relevant is if there is an overt act that gets testified to, prior instances of violence by the decedent that she is aware of. That doesn't open the door to hearsay. That doesn't open the door to any of these things that he seems to be referring to, whether it's criminal rap sheets, which is what I believed he was referring to, or police reports, or state attorney records of no bills, or I don't know. Based on his last statement, I don't know what we're talking about now, but we do have hearsay objections to, I thought we were talking about physical exhibits. And that's what our objection would be to believing that what was represented was a criminal rap sheet.
In addition, in her mind, she felt like the state attorney had murdered her and could not, they dropped 3 of the cases, so she felt helpless that there was some outside entity that would protect her. That ties into her state of mind as to whether or not she felt at the time of this event. So that may become relevant depending on what Dr. Harper says, Dr. Wood says about that, what Dr. Brandon says about that, as to whether or not she felt helpless because the state attorney's office was not prosecuting George Torres.
But that all sounds like oral testimony. And again, this goes back to this is an exhibit list. What are the exhibits? Tangible, physical. Okay. What does that have to do with prior criminal history? Because that's the topic here. Prior criminal history of George Torres Jr. not yet received by the defense. That's the line item in your exhibit list. Okay. All right. So based on counsel's representation of the withdrawal, the court will not sustain or grant the objection. Does that clarify that for you, Mr. J?
Thank you.
All right. Moving now to 19, Orange County Sheriff's Office investigative workup report. Response. Okay. With that understanding, Mr. J?
Yes, I'm not clear what a workup report is, but if it's not sought to be introduced into evidence, then I will accept that representation.
Okay, so accepted. Your objections overruled based on counsel's representation. The investigative report workup will not be offered into evidence, but merely for refreshing. Moving to 21, all court orders in all Orange County criminal cases regarding George Torres. State. Any further argument?
I believe we went from 19 to 21 without addressing 20.
Oh, I apologize. I had the wrong, I color coded this and I miscolor coded this one. Okay, then based on counsel's representation of withdrawing that, the court will not rule on that objection. Moving to 21, anything further, because it's kind of, we kind of addressed this as well with number 19. Anything further, argument state. Anything further, argument. Okay, I'm going to overrule the objection as to, as this point in time, because if a declination of prosecution may have been filed, that may be relevant based on Ms. Boone's testimony. So I'm going to overrule your objection at this time, assuming the overt act concept is placed into evidence. Moving to 22, family law case file Boone v. Boone, case number 2017 DR 01660-0. I understand the state's objection as to relevance and hearsay. Response? What does the non-payment of alimony have to do with what's happening in a family case?
That goes to his testimony.
Owens is trying to compare apples to like papaya.
Response?
Sounds like this is ongoing pending litigation that has not been decided by a circuit court judge of Ninth Circuit Family Division. I can certainly understand why one may believe they don't need to pay alimony when their spouse is incarcerated. I can certainly understand why somebody may believe they don't need to pay child support when their spouse is incarcerated, and they would probably want to seek legal redress about those issues. And it sounds like it's all ongoing.
Are there any orders from the court in that case addressing the non-payment of alimony and that being contemptuous or in violation of any court order?
No, they were divorced. I think there was a marital settlement agreement that was attached to the final order. Brian Boone did open the case back up to move the child to Gainesville, which has happened. And then my understanding is there's still some issues. I think she was given some kind of a notice of the hearing coming up. She's not represented. I don't represent her.
Is there, so if there's no order in the court file finding there's a violation of an order to pay alimony, what is?
Well, there's a final order about his obligation to pay alimony. And I think if he gets on the stand, I'm going to ask him, but you haven't paid her alimony like you were ordered to do so. I can go into under cross-examination.
But it sounds like there's pending litigation, including a relocation and I don't know because it's not my case. I haven't looked at it.
That's been decided. He has been able to relocate. I don't know all the ramifications. I'll look at the court file. I think we had subpoenaed the custodian of the records of the court file. I'll look at it and I'll let the court know and the state know.
Can you all approach this for a moment?
Oh boy. They're going to skip through all this because I don't feel like looking at Sayer's ugly mug. My opinion. Who was that smile from her for paralegal? Like getting all chummy with a murderer. Allegedly.
He's filed.
Okay. Sorry. Too far.
Intend to introduce.
As such, the court will not take any action on that objection. 33, another iPhone photo file name. Court's not going to read it because it is too long.
Defense does not intend to introduce.
Based on counsel's representation, court takes no action on the objection. Moving to 48, another iPhone photo file name 505 period JPG underscore embedded underscore 1 underscore 772.
We would stipulate.
The objection is sustained based on stipulation. Moving to 59 and 60. I understand your objection state. Any response?
Any and all exhibits previously listed by the state.
Yes, sir.
Judge, Mr. J is a smart lawyer with a lot of experience. He's board certified. He's filed this motion in limine to disallow the battered spouse syndrome twice. And yesterday, we were forced to disclose the overt act that constituted our defense that tied in with the self-defense. And so practically he was able to get us to that posture so he knows our defense and how we're coming at it. The problem is the state has not been forced to give the details of what they allege Sarah Boone's overt acts or non-acts.
I need to clarify something. There was no forcing yesterday. The court reviewed Dr. Harper's deposition, and there was no overt act that she had testified to. She was specifically inquired about any imminent fear, and there was no response to those questions. The word overt act did not appear in any of the 4 or 5 sessions that she had with Ms. Boone. And state was seeking, as we addressed yesterday in limine, to prohibit that.
I disagree with that. That was his deposition. He tried to control the witness. He kept cutting her off. He wouldn't let her finish explaining. I certainly wasn't going to do it. She's going to testify in trial about it. It's not my fault that he felt like he got the answer he wanted and he moved on. He didn't ask for any elaboration about that. But that's going to come out. But I understand that's all you had. But we had to do that. The state has not had to do that. And I understand under the 6th Amendment that we have a right, the accused has a right to be informed of the nature and cause of the accusation. And the problem with that boilerplate information is we don't know what they're claiming that she actually did, overt act or omission, that constituted second-degree murder. So because of that, we have to list everything because we don't know. It's like he wants to know. He wants the court to make rulings so that he can tweak his opening statement based on the court. The same with us. We don't know how to respond to their opening until they give it because we don't understand the full nature of what they're alleging Sarah Boone did to constitute second-degree murder. So in an abundance of caution, we've got to list everything that may be relevant, but we don't know yet because we haven't heard. I would like to renew, they've renewed their motion on battered spouse. I would like to renew my motion for a statement of particulars so that I could know, the defense team could know what it is exactly that the state attorney is alleging that Sarah did or did not do that constitutes second-degree murder. It's a serious charge. This is not, it's a unique case. It's not something that happens every day. And that's why we believe that it was proper under that rule of a statement of particulars so that we could be informed about what it is exactly that they claim that she did criminal so that we could prepare a defense. And it goes to directly to this point, which is they want to know why we want these documents and what documents specifically are y'all going to use. Well, it's difficult to tell when we don't know what we're accused of.
Any response, Mr. J?
Yes, sir. Mr. Owens, Mr. Cacciatore,
Sorry. If you don't know what you're being
Myself,
accused of 4 years after you
Dr.
did it,
Werner, all sat together within 5 feet of Sarah Boone, first week of October, and heard the final version. It's not very dissimilar from the version of Dr. Harper, but Dr. Werner's deposition was provided to the court previously for our motion to eliminate. I don't understand the position they're taking that they were forced to show their cards when Dave Cacciatore and myself,
Mr.
Mr.
Chicken.
Owens and Dr. Werner were all there together to hear her version. And her version is, it was all fun and games. It was Sunday fun day. He gets into the suitcase. We're all laughing. I zip it shut. We're still laughing. There comes a point in time when he says, I can't breathe. This triggers her based on her past abuse, no overt act that day. And she begins violently doing the things to the suitcase that she says she did, whacking him with the baseball bat on his fingers. And now, after being the initial aggressor, now after having committed a forcible felony or two, now after having put Mr. Torres in a reasonable fear of death or great bodily harm, she says, well, she realizes now if he gets out after these things that I've done to him, I'm in big trouble. And it's my understanding that we have had this discussion, and that if that is the proffered testimony, that is not going to amount to an overt act, which will allow for reputation evidence, past incidents of violence, or the battered spouse syndrome evidence. That they weren't forced to show their hand. I was there. The rules of criminal procedure allowed me and Mr. Cacciatore to be there and to witness this evaluation. So that being said, we're not abusing the system. We're not doing anything that we're not allowed to do. And we're making every effort to make sure that we understand how this trial is going to go down and how Ms. Boone understands how the trial is going to go down. Because my understanding of how it's going to go down is she's going to have to testify to the specific events of that day. And right up when she comes to the point to saying, and when he said, I can't breathe, the state attorney, Mr. J, is going to object. He's going to ask to approach. He's going to say, Judge, there's been no change in her testimony, unless there is. Then that's a whole different bag of worms. But if there's been no change in her testimony, Judge, we got a ruling
Which
prior
worms
to
in a
this.
bag?
There's been no overt act testified to. Now we're going to object to her answer of because of the past violence, and we're going to object to any further attempt to bring in prior violence, reputation evidence, or battered spouse evidence. I just want everybody to be clear and on the same page about that. Now, in regards to their request, a renewed request for a statement of particulars, they've had the discovery for several years. This is the state's case. A video that starts at 11:12:45 p.m. on 2/23/2020. Sarah, for everything you've done to me. Sarah, for everything you've done to me. Sarah, F you, laughter. Sarah, F you, laughter. Sarah, stupid. Sarah, that's my name. Don't wear it out. Sarah, I can't effing breathe, baby. Seriously. Yeah, that's what you do when you choke me. Sarah, 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 laughter. Sarah, I can't breathe, babe. Laughter. That's on you. Sarah, I can't breathe. Laughter. That's on you. Sarah, unintelligible, drunken, slurred words. Laughter. Sarah, 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 I can't breathe, baby. That's what I feel like when you cheat on me. Sarah, F you. I can't effing breathe, Sarah. You should probably shut the F up. Sarah, shh. That's our case. That is an evinced, depraved mind, conscious disregard for whether he lives or dies, whether she put him in there or not. She let him remain for 2 minutes during that video. And then at 11:23:03 p.m., there's another 22-second video, and it just zooms in on the suitcase. Sarah. So that is a second-degree murder case when the medical examiner comes in and says, George Torres died from positional asphyxiation and the asphyxiation of being in a confined space. And eventually, after Lord knows how many breaths, he expired in that suitcase when she went upstairs and went to bed. But in addition to those statements, we now have her new statements, which are she intentionally violently shook the suitcase, threw it upside down, hit him with a bat, committed independent forcible felonies. And that's going to be corroborated by the medical examiner's testimony to all the blunt force trauma to both sides of his face and his mouth. That is a second-degree murder case. That is what we're going to be presenting. This is a portion of what I will be telling the jury this afternoon.
Any rebuttal?
I wanted that in writing weeks ago. She was assessed, Sarah Boone, the defendant, was assessed at the Orange County Jail a couple of weeks ago by Dr. Warner. Their rebuttal states that. The characterization that Mr. J just gave about her testimony, I do not agree with. There was 4 of us there. Dr. Werner, 5 of us there. Dr. Werner, Sarah Boone, myself, and the 2 prosecutors. The mistake we made was not recording that assessment.
That's not
Because I
state's
can't
fault.
testify to what she said. The two prosecutors can't testify to what she said. The only two people that can testify to what she said is Dr. Werner and Sarah Boone. We dispute their characterization of what she said. That's just going to have to be testified to by Sarah Boone and the Dr. Werner. And jury, while we're here, they are going to have to decide who to believe and what happened. But that is a jury question that we're all going to have to wait for. I appreciate the prosecutor giving me the evidence he intended to introduce to prove equity. Something I was asking for a couple of weeks ago. Thank you.
For the same reasons that the court identified when we had the hearing on the original motion for particulars, the court relies on its same ruling in the case law identified at that time. The renewed or tennis motion for a statement of particulars is denied. The state's objections as to paragraphs 59 and 60 are also overruled. The only other issue to address then is the Richardson violation. Court's going to take a short recess, and we'll address that as promptly as possible. It is 5 till 11. I still intend on moving forward with jury selection this morning. We will be moving to 23, correct?
Yes, sir. I'm just making sure I'm clear on 60. Our request was that prior to the testimony of any of the listed witnesses, which I listed only by initials, that we have the opportunity to depose them and we address the cost of expedited transcripts. I just want to make sure that we overrule that.
I apologize because I was just looking at what was articulated in the exhibit list, which was any and all relevant reciprocal discovery to be obtained through ongoing investigative efforts. What's your response, Mr. Owens, with regard to these persons identified in the state's objections who may be called and deposing them?
Well, the state listed a bunch of witnesses on October 3rd. Well, if the court allows the state to do this and take the depositions, then we ought to be allowed to take the depositions of their witnesses they listed.
I believe those are the same witnesses that they've listed in regard to the prior incidents. The deputies that went out in the call outs and the cases that resulted in cases in the state attorney's office and 911 dispatch.
Okay. Is that accurate, Mr. Owens? That October 3 state's list?
We don't dispute that they should be allowed to depose them, but they've been listed by both parties, whereas these people are unilaterally listed by the defendant.
Judge, again, I'm not complaining. Been on the case 45 days as we have gotten witnesses or found witnesses, Billy Lane or whoever else was trying to locate him on my team. We have tried to disclose based on what Sarah Boone has asked us. This witness, we've made attempts to comply with her request. Whether or not we're going to call them, the law says, the case law says, Sarah Boone has a right to trial. Sarah Boone has a right to testify. Sarah Boone has a right to appeal. I believe those are the three fundamentals.
She should have taken the plea deal.
Makes the decision about which witnesses to call. So although she may want some witnesses, she's asked us to find them and list them and locate them, which we've done. That doesn't mean that I have to call them, and it may not.
Inhale deeply through your lumen.
I believe my right to do that and to present our defense with our witnesses is paramount. And she does not have the right.
Okay, thank you. All right, court's going to take a brief recess to address this and the Richardson violations. We'll be in a short recess. Thank you.
Skipping ahead. I don't like looking at the clock. It's kind of boring. Geez, they were on a long recess.
Is 11.
This is the part that I didn't get to.
All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State appearances for the record.
William J.
Defense.
So James Owens for Sarah Boone.
Ms. Boone is seated at council table wearing the same clothing from earlier this morning. All right, it is 11:24. With regard to the Richardson hearing, with regard to item 6, the defendant's fifth amended reciprocal discovery list, the court is going to reserve and have that hearing tomorrow morning at 9 a.m. Defense is to provide an edited version of only the records that pertain to anxiety or their lack of thereof to the state before 9 a.m. tomorrow morning.
Judge, number 6 was triggered.
Okay. Did that happen when I was not here?
No, it happened earlier while we were here.
And what specifically was the Richardson violation for then, if it wasn't for number 6? And I apologize.
Number 2 is the 119 new JPEG pages, according to be from Winter Park Advent Health, and they're a little bit different than the 81 pages that I previously received.
So the ruling remains the same. Court's going to reserve, address the Richardson hearing tomorrow, and you were to provide an edited version of those records that you seek to offer into evidence. Mr. Owens, before 9 a.m. tomorrow morning.
Regarding the paragraph number 2, regarding the Winter Park Advent Health records, the 119 that we gave him this morning.
That is correct, sir. With regard to the witnesses that have been identified by the defense in paragraph 60 of the state's response, those witnesses will be excluded if not deposed prior to being called as witnesses, and the defense shall pay for any and all expedited transcripts.
Hey,
Our judges,
welcome, Mo Raiders.
There were 3 people that they gave us late that we didn't have before: Rachel Finner, Meredith McCaskill, and Victoria Shelton.
State response.
Meredith McCaskill is an FDLE analyst that is substituting for an analyst that's unavailable during the trial period. So in an effort to not continue the case, got a substitute analyst. That's our reason for the late disclosure on her and with the other 2.
Michelle Finner and Victoria Shelton.
And those are the 911 dispatchers. If we end up having to call them, then that's fine. We will take the expedited transcripts. What I would expect might not be lengthy nor expensive.
Okay. Has the FDLE analyst that was originally set to testify been deposed in this matter?
Mr. Cashtori does not believe that the defendant can ever depose that person.
Any other positions, Mr. Owens? Okay, all right. State will afford the same opportunity to the defense as provided by the state to the defense. Court's going to be in recess. It's 11:27. Hang on. Juror number. Yes, let me address that. Can I have that thing again, please? If you all still have yesterday's sheets from jury selection, Madam Clerk has advised that jury services has told us the juror in seat 25 wearing badge 63 called. The nephew that she cares for is ill and that she is not here due to caring for that child. He is not here due to caring for that child. State's response, if any. So stipulated, juror number 25 wearing badge 63 will be struck for cause. We'll advise the jury services to call them and tell them they do not need to report. With regard to the order tennis motion as to Ms. Boone's request for snacks, the order tennis motion is denied. Ms. Boone is being provided all the same services as to any other inmate being transported for the purposes for trial.
No
Anything
snacks
else we need
for
to
you.
address State before we report back to 23 at 1 p.m. Defense?
Yeah.
All right, we'll see
You
you
have
all at 1 p.m. Thank
requested
you very much. Court's off the record.
Pop-Tarts, peppermints, things. No snacks for you, Sarah. No snacks for you. All right. Well, I'm going to stop sharing that. So it sounds like they have a jury. No beauty crew either. She gets what she gets. Like, the Pop-Tarts are in the car. I forgot them. I might break them out specifically for Sarah's trial because I'm petty like that, and we play here in the pettyverse. Like we play in the just remember, this is where we live. We make our living in the pettyverse. I can't. So I'll watch the trial eating Pop-Tarts and peppermints. So Flash Fan is monitoring what they are going to do today. I disappeared for a second, and Baby Squid let me know that her iPad stopped working for a second. She's got like 4% battery life on it, so She's had it while I've been live streaming, and once it's dead, she's done for the day. Anyway, I don't see no jury yet. They were breaking, yeah, and they were originally had one, and then they started striking people. So who actually knows at this point? It is one of those, if they decide to do opening statements, I'll do them tonight. If not, we're going to talk about Carly, because we still haven't talked about Carly Gregg and the updates in that case. We started to the other day when we got rudely interrupted. So we'll do that tonight after she goes to bed. Yeah, I did feel frozen this morning. It was only 35 degrees when we woke up this morning. It was cold. It was cold. It's only like 66 degrees in the house. Ugh. Anyway, later. So the internet's being the internet, so I'm gonna call it a day. It was fun hanging out with y'all today. And we will see who else is, if there's anybody that is live right now. We will see. Let's go. Hey, little one. Now that I can redirect, we will see. Customization. Anybody have any requests? Megan's still live? Megan's still live. Megan it is. All right, guys. You have a great rest of the day, and I will see you later tonight.